Good afternoon, everyone. This week's legal live stream is on a very, very interesting question. It was sent in by Meredith Stark via DM. And the question is, do we have a constitutional right to vote? Does the U.S. Constitution, not by statute or common law, but does the U.S. Constitution give us a basis to have elections? And I didn't know the answer right away. I was inclined to think yes, because, well, you know, there's a lot of amendments that talk about our right to vote and how it shall not be abridged or infringed upon. But when I started researching this question, I was shocked to learn that the short answer to the question of, do we have a constitutional right to vote, is no, we do not. We do not have an explicit constitutional right to vote. The other thing I wanted to mention is right now our elections are pretty much run by two political parties. They hold an inordinate amount of power over the way our elections are held. But the Constitution also does not mention political parties anywhere. So there is no constitutional right for political parties to exist or even survive. So what I'm going to do is I'm going to go through what I have read in the Constitution and the amendments to the U.S. Constitution that touch upon voting. And when I did the research for this question, I had a much better understanding of how our elections work and what is the Electoral College. And by the way, these notes that I'm reading, they're not real notes, they're just they're portions of the Constitution and the amendments that I've excerpted. I've uploaded them in the referenced documents link. So if you want to take a look at this paper that I'm reading from, please feel free to download that document yourself. The first thing I'd want to mention is Article 1, Section 2, Clause 1 of the U.S. Constitution, okay? And it says that the U.S. Congress, House of Representatives, must be chosen by the people. That is explicit, okay? So in our Congress, the House of Representatives, those representatives shall be chosen by us, the people. Okay. But it's only talking about the House of Representatives. Then, if we go on to Article 2, Section 1 of the Constitution, it states that each state legislature, okay, all the states, they're the equivalent of state congresses, they may appoint a number of electors for the presidential elections. So this is the Electoral College. And it goes on to say that the number of electors is the number of representatives and senators that that state has in Congress. So now each state has X number, and it's different for each state, right? Has an X number of elector slots that are allocated to it. But what's important to note is that the Constitution doesn't state how these electors will vote for the president. Excuse me. So I'll give you an example. The way our elections run now is that presidential candidates, they run and for all the electors for a state, they generally follow a winner-take-all rule based on the popular vote. So, yeah, that's why, you know, when you see the electoral map on CNN during an election year, the entire state turns blue or red. Okay, so that's how the states have decided to run their elections, to determine how their electors will vote. These electors, which are appointed pursuant to Article 2, Section 1 of the Constitution, they're not constitutionally obligated to vote the way the popular vote in their state has gone. They agree to, but they're not really obligated to follow that. And although it's very, very, very rare, it has happened that once in a while an elector would refuse to cast his or her vote for the president following whoever won the popular vote in that state. I know that there's a few other states that don't follow the winner-take-all rule. In other words, if 51% or above of the people voting voted for a particular candidate running for president, all of the electors in that state are given to that candidate. Okay, that's winner take all. Not all states follow that, most do. So that's how we have been electing our presidents so far. But there is no constitutional mandate of this winner take all policy, or even that we have a right to vote for our president. Now, I'm going to now go on to talk about the amendments to the Constitution. Okay. If you read the Constitution, this is the way it was done a long time ago. The candidate who got the most number of electors became president, and the runner-up became vice president. That would be, I guess that would kind of be like Secretary Clinton would be Veep to President Trump. As you can imagine, maybe people didn't think that was such a good idea. So the 12th Amendment revised the Constitution so that the president and the vice president always run together. So they're a team. So they rise or fall together. And having somebody that you ran against, now that you're sharing the president and vice presidency, that doesn't happen anymore. That's the 12th Amendment. The 14th Amendment to the Constitution, it talks about how representatives are proportional to the population. So this is why we have 2 senators, but the number of representatives in the U.S. House of Representatives depends on how many people generally are in the state. Now remember, the electors that we have are tied to the number of representatives the state has. So the 14th Amendment indirectly impacts voting because it determines how many electors a state has. And I'll talk about the 14th Amendment in a little bit. It's a very interesting amendment. But moving on, the 15th Amendment, which was ratified by the states in 1870, states that you cannot discriminate or prevent people from voting based on race. The 19th Amendment, which was ratified by the states in 1920, gave women the right to vote. That was less than 100 years ago. The 24th Amendment, which was ratified by the states in 1964, said that tax evasion, or the fact that you didn't pay taxes, cannot be a factor in voting for the president, the vice president, the electors, or Congress. The The 26th Amendment, which was ratified by the states in 1971, lowered the voting age to 18. Some of these amendments talk generally about elections. The 24th Amendment is very specific about what types of elections it applies to. So that's it. Under the Constitution and the amendments, that's pretty much what I saw as the most important clauses and amendments that deal with voting. How have courts dealt with voting disputes in light of the Constitution and the amendments? Two very important cases that came out was the Bush versus Gore case and the Shelby County versus Holder case. This show is, I would say that for me to go through all of the court cases that deal with voting, it's beyond the scope of this live stream. But I can tell you that cases brought in court based on constitutional grounds that relate to voting, there's a lot of them. Bush v. Gore was one, Shelby County versus Holder was another. And my takeaway from both cases is that the courts tend to, right now, they're in a trajectory or a trend of allowing more state latitude in controlling how elections go versus federal oversight. For example, in Shelby County versus Holder, the Supreme Court held that state and local governments are not required to obtain federal pre-clearance on how they run their elections. They can just go ahead and do it, make their changes. A lot of people were concerned about Shelby, but it does give states a lot more latitude and less federal oversight into how they run their elections. So one thing I wanted to talk about is, for those of you who have been following the DNC fraud lawsuit, if you recall, the lawyers for the DNC and Congresswoman Debbie Wasserman Schultz, the defendants, he stood up in open court, and I'm paraphrasing, but he said that it would be entirely legal for party leadership to go into back rooms and pick the candidates that way. And if you look at the Constitution and the amendments, there is nothing in here that would prohibit them doing that. So in a way, he's right. The issue is, if you are going to do it that way, then having people believe something else, or the fact that we have a say in how elections are run, would be misleading. And this was one of the arguments that certainly I have discussed in interviews, and it was presented to the court as a fraud case. And of course, if you defraud somebody, that's not an unconstitutional claim. The Constitution doesn't say that you have a right not to be defrauded. Fraud is a common law claim. It doesn't arise out of the Constitution. It's a very, very old claim that is even older than the Constitution. Okay, but it's no less valid in its own way. So if it is indeed true that we don't have a say in how the candidates to the presidency are chosen, or how ultimately the president is elected, then I think that we, the voters who go to the polls and vote, take time out to vote and research candidates, we are entitled to know that, and to know that our voting doesn't mean anything. Whether or not that is true is something that has not completely come out. I know that Ms. Donna Brazil wrote an article for Politico that came out a few days ago that spoke about how the Democratic National Committee, which is a private corporation, it's a private corporation, essentially did not run a fair and impartial primary campaign when Secretary Clinton, Senator Sanders, and other people were in the running for the Democratic nomination process. So I want to end with a little discussion about the, let's see here, Section 2 of the 14th Amendment. All right, so I'm going to read Section 2 of the 14th Amendment. This is very interesting. Okay. Section 2 of the 14th Amendment to the Constitution, to the U.S. Constitution, states that let me see here. When the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, being 21 years of age and citizens of the United States, or in any way abridged, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. The way I read that, now remember, some of the clauses in the 14th Amendment, such as the fact that you have to be at least 21 and a man, were overridden by subsequent amendments. But it basically says that if the right to vote is in any way abridged, then there shall be a penalty. And the penalty is that you lose, that state loses part of its proportion in Congress. And I think that's a very, very powerful penalty. It's written right into this amendment. The interesting thing is, when I was researching this, I read an article by The Nation, and it said that this Section 2 of the 14th Amendment has never been enforced before. People just overlook it. But in some ways, it seems to have a built-in penalty, in my very quick reading, to penalize states for election skullduggery, okay? Because it doesn't talk about discrimination against a particular group, okay? It just says that if you abridge people who can vote, if you abridge their rights to vote, then you're going to lose representation. Okay. When I was researching this question of whether or not we have a constitutional right to vote, I read some articles, and some folks think that all these amendments, that you shall not discriminate against race or gender, implies a right to vote. But I don't think that's necessarily true. And the reason is, I'll give you another example. Let's look at employment. Okay. You cannot discriminate in your workplace based on race, gender, religion, and so forth. Okay. Once you open up a business and you hire people, you can't discriminate. But you're not obligated to hire anyone to begin with. But once you do, then those protections kick in. So the question is, even though we have all these amendments that prevent discrimination against certain groups in voting, that doesn't necessarily imply that you're entitled to have voting to begin with. And as a matter of fact, if you look at Article 2, Section 1, it states that the president is elected by electors, which are then appointed by the state legislature in however way they want. They can They can do it the way they've been doing it currently, which is we go and we vote. We actually vote, and many states do the winner-take-all method. But they don't have to do it that way. They really don't. It's whatever our legislature, individual states' legislatures want to do with the number of electors that they have been allocated. Does anybody have any questions? Hopefully this has been educational. It's been educational for me. Let me see here. Hi, Helen. Hi, everyone. Yes, Amy. It has never been enforced. According to the Nation article, and I haven't had a chance to actually go into Westlaw and see if the Section 2 of the 14th Amendment has been brought in any case which resulted in opinion, in a court opinion in Westlaw. I may do that, and if I find anything interesting, I'll upload it. But if you look at the, if you read the Nation article, and I put the hyperlink in the document which I've uploaded, you can read it yourself. It says that it's pretty much a dusty little clause in the Constitution that nobody's really paid much attention to, and it's never been enforced. So I think that's very interesting. Does anybody have any other questions? So we're a little bit over 20 minutes, 21 minutes. So I will end this call, this live stream, by saying that if you found this educational, please help me continue to do these weekly live streams, and you can be a sponsor on Patreon. If you are a patron on Patreon for the Cranky Lawyers Legal live stream, I have some ideas. I'm going to do live streams for patrons only and do all sorts of fun stuff. So this is only the second episode ever of the Cranky Lawyer Legal live stream. So I invite you to, if you like what you see and hear, and you find the documents that I upload to be educational, please consider sponsoring Cranky Lawyers Legal live stream on Patreon. Thank you so much, and have a great rest of the weekend.